Hey, it's Rob Ryder. It's Saturday, October 24th, 2020. And this is about the administration of justice, which, if we could ever make happen, would make our lives a lot easier. And it's based on some things I've had going here recently. Which the easiest way to find them would be to go to my YouTube site, Rob Ryder with 3Bs, ROBBBRYDER. And you might have to go back as far as Gretchen has a hearing to kind of catch up with what's going on, but nevertheless, that's how it's done. So, in our particular case, this last week, in a case in California I'm helping a lady with, we had filed for an ex parte hearing, and when they had the hearing, the judge said you couldn't do that. Couldn't be an ex parte hearing. Had to notice the other party. And they wanted to reschedule the hearing till later on. And at first, that's what we were doing. And then looking into it more, I say, well, no, that's not what the law says, right? This man is, he's abusing his authority to determine what the definition of ex parte hearing is. And so who's in charge of administration of justice? Go complain to them and make it administrative instead of judicial, because he made a judicial decision, or he made a decision in a case, but he did it based on administrative understanding, right, of what his duties are, and he overstepped his bounds. So in California, hey, they actually have an office that's in charge of administration of justice. And like in Michigan, they have a thing called the chief judge rule, where they're supposed to be over the administration of justice within their jurisdiction. So like at the general civil court, here they call them circuit courts, that chief judge is supposed to also have, it's a proper term, right? Supposed to have administrative control over the administration of justice, right? Basically, he's the clerk of the court, in charge of administration, and he's the chief judge, wearing two hats. Anyways, so let's go complain. Let's not just pay for another hearing. Let's go complain. And that was what we're doing there. And then I had done a couple of cases into the, I already got rid of it, into the mother court, which is the Southern District of New York, United States District Court, because it had a miscellaneous case cover sheet that you could fill out, that if you've ever looked at the federal cases, they have this thing called a civil case cover sheet they want you to fill out. Well, that's one style of court case, a civil case, but there should be this miscellaneous case also, which costs $46 to open, or $47 to open instead of $400, right? And so that's what I'm trying to do. And if you get into that miscellaneous case side, well, that's where equity is. And I did, that's my last video was on, was where this equity jurisdiction came from, and we'll talk about it a little bit more, But, that's where we're headed with this, just to fill in what's happened since the last time I did a video. It's been a busy week. And, so I'm Staff Sergeant Robert Allen Bertluski, United States Army veteran. Thank you very much. If you're a veteran, don't let them ever take it from you. You still are in, right? Claim it. But I go by the avatar Rob Ryder, and my email address is courtofrecord@aol.com, which is, usually the best way to try to get a hold of me. You may have to do it more than once, but that's how I get people's attention. I send them a second notice. Hey, I guess you do want me to talk to you. And this thing about being the veteran, right? Now, this is big for all veterans, because one of the things I've put into the United States District Court in New York is, about veterans, and the fact that our DD-214s all have errors in them. And none of us have ever been released from the military. We're still in. In fact, let me show you this right now. I mean, people can say what they want right? But there's always the law, and this is Title 10, which is the Armed Forces. So this is Title 10, United States Code, Section 246. And as you can see, this got the little eagle up in the corner, right? So it's been authenticated as this is the law according to the government printing office. And in Title 10, United States Code 246, it says the militia is, of the United States, consists of all able-bodied males at least 17 years of age, and except as provided in Section 313 of Title 32, under 45 years of age, who are or who have made a declaration of intention to become citizens of the United States, and of female citizens of the United States who are members of the National Guard. So all these guys in Michigan now that are going to federal court because they apparently were trying to kidnap an imposter pretending to be the governor of Michigan, Gretchen Esther Whitmer, who's, she's an esquire, man. She's an enemy of the United States. She should be arrested. Well, instead they arrested these guys. Well, they all need to claim, look, I'm a member of the militia according to United States Code, and I demand a trial by court-martial. Right? Because you're not getting a trial by court-martial right now. You're getting a trial. They are going to be tried in a federal court with a gold-fringed flag that's not a court-martial court. It's a provost court or some other military tribunal, because we've been under martial law since 1861. Can't get away from it. Right? And the only way martial law is ever going to end is when Article 2 of the Legal Code has been satisfied. Doesn't matter what any de facto government says will end martial law or anything else. The only thing that's going to end martial law as far as the Army's concerned is when its fucking orders have been carried out. Right? And you need to understand that. Right? So, we're dealing with the Army. It changes things a little bit. And so, that's why, I'm a veteran, man. If we're under martial law, which we are, and I'm a veteran with honorable and faithful service, then I'm an asset to the government, military government over the United States, out here in the district. This is why they don't want to give veterans ID cards. Because if we had our Geneva Convention ID cards, we could walk into a police station and file a report, and they'd have to treat it like it came from a federal agent. Or go down to the armory and file a report, whatever it takes. Go fill out the sworn statement form they have for the military. Right? You got an ID card, you can fill it out. And when you do, well, it will be investigated. Well, that's why they don't want us to have the ID card. And, these are things I've done videos on over the last few years that, they all pile up. It's like, well, how are you ever going to get past this shit? Well, it's getting justice, right? That'd be the way to do it. And so who's administering the justice? Let's go find them. Well, in the federal court, it's done in equity, which is done under the laws of Court of Chancery. I won't say laws, but the process of Court of Chancery. Been established for 1,000 years in England. Right, so it is the common law. And it said, I showed in my last video, that the process of equity is done by the civil law. It's not done by the common law. Right? It's not an adversarial proceeding, so there won't be a plaintiff and a defendant. There would be a petitioner and a respondent. And so we need to go to the door that's equity and not the door that's common law, which is this case they want you to fill out with the civil case cover sheet. So anyways, more on that later. I'll be rambling a bit today because there's a lot of history where this stuff comes from. But let's look at what administration means. The act of administering direction, management, government of public affairs, and the conducting of any office or employment. All right, but here's the big one. Dispensation, distribution, exhibition as the administration of justice, of the sacraments, or of grace, right? So to have justice done is, that's religious. Corinthians. And there are differences of administration, but the same Lord. Right? So apparently it can be done different ways, but it all has to answer to God. So somebody better be doing it the proper way. For the administration of this service not only supplieth the want of the saints, but is abundant also by many thanksgivings unto God. I'm just saying there's a storehouse of grace somewhere waiting for us to tap into it, and we haven't found how to, turn on the hose of administration of justice yet. But when we do, we'll no longer be in this famine, living in a world of lack. Now, one thing that's important to remember, because I'm going to be showing that, what we did is we asked for an ex parte hearing in California. Well, Black's law, right, further defines ex parte as something being made by one party, done or made at the instance and for the benefit of one party only, and without notice to, or argument by any person adversely interested, or relating to court action taken by one party without notice to the other. So that's what we were trying to do, have an ex parte hearing. We weren't going to notice the other party. We didn't need to. He'd already done what we had said had happened, so we're just bringing it to the court's attention. And the judge said, well, you need to notice the other party. And he got Christina to agree to that. I mean, coerced her into agreement. She really didn't have a choice, and, they didn't have the hearing they were supposed to have. By definition, ex parte hearing is done on the application of one party. Well, that's what we did, right? So this is what I'm sticking on. That's what Black's law said, right? I can go point at what I'm using. Now, if they want to say that we have to have one, well, show me the law that says that I do. And then prove that you have the authority to be using that law anyways, because, as I've shown, these judges don't have the oath that's in 4 U.S.C. 101. They haven't satisfied 6th Article of the Constitution of the United States. They don't have any fucking authority in the United States. None of them. So they don't have any authority to tell you what to do if you're a citizen of the United States, but they do have the authority to tell attorneys what to do because they're part of the same society. They volunteered. Right? And they want you to volunteer to be in that society where they're an esquire, which is one step down from a knight, and below an esquire is a mister. Right? That's the knaves. They want us to be the knaves, the misters. They're the esquires. Right? So we don't have any rights compared to them. And that's the court they take us into. They take us into the attorney court, or the attorney door. Well, we don't want to go to court attorney door. We want to go to court in personam, right? In our own person. And so if you look at a civil case, it'll say you're a pro se attorney, but it won't say that you're a pro se party. But it does say you're a pro se party in miscellaneous cases. All right, check those boxes. Check, check, check. Okay, so let me ramble on here to get what happened in California first. Let's start there. So give me just a second. Okay, so this is the wonder of the internet. Here's the register of actions for the courts in San Diego. Go figure. Superior Court of California, Court of San Diego, register of action. You could look up any case on there, and by God, here's the one we're looking at. And in this case, back at register of action number 28, right, we were trying to have this hearing for an ex parte application. Now look at it. We go from 28, 29, and 30 are missing, right? Then there's 31, 32, 33, right? But there's 2 of them missing. And they did that before, and they had an excuse for it back in the day. Actually, it was just before 16, if I'm not mistaken. Right, where there's these blanks in the frickin' register of actions, which is supposed to be the official record of the case. Well, then why is 29 and 30 missing? Where are they if it's the official? What's their excuse this time? But anyways, so we wanted to have this hearing, and we have the hearing on the 14th, or, Christina's having the hearing. All done by phone or Zoom or whatever they're doing. You can't get into court anymore. But the judge is saying, well, you didn't, notice the other party. And he ended up issuing an order, and then he wanted her to reschedule and so forth. And so that's what we're going to be talking about. But let's look at his order then. So what did the order say? It said, right, this is him, Earl H. Moss. They got a clerk, everybody who is there. What's this say here? Reporter. Court reporter not requested. So this wasn't being recorded. Now, who had to request a court reporter? And why weren't they there? But it did have a bailiff or an attendant, so which one were they? But defendant's ex parte application for OCS, order to show cause, contempt, and malicious prosecution is taken off calendar. Defendant did not give notice of ex parte hearing to plaintiff's counsel. The court continued the ex parte hearing to the 28th at 8:30 at defendant's request. Further, the court advises defendant to give notice and serve ex parte papers to the plaintiff's counsel. Ex parte is continued pursuant to party's motion to 10/28 at 8:30 a.m. But they wanted to make her pay for it again. So it wasn't really continued. It's like they had, it's not that they went on recess and they're coming back. They shut her down and want her to refile and pay for another hearing. So, $95 a pop, it starts to add up. So, we could do this. That's the guy's order. It's easy enough to do. Well, let's do what the judge said. But, while we may have the hearing, I had her unschedule it for the 28th just to see if these other things we were going to do would have any results. And so what we did is we contacted two different places, but one's the judicial council, which is really the one that matters. Right? So this is California courts, the judicial branch of California, judicial council. The judicial council is the policy-making body of the California courts, the largest court system in the nation, under the leadership of the Chief Justice, right? The Chief Justice is in charge, and in accordance with the California Constitution, the council is responsible for ensuring the consistent, independent, impartial, and accessible administration of justice. Judicial council staff help implement the council's policies. All right, well, then they're in charge of the administration of justice. And I'm saying, well, we're not getting any. Let's write them. All right, let's write the people who are responsible for it and tell them they're not doing a very good job. Let's go complain to the council. And so that's what we did. This week, and now we're waiting to hear to see what they have to say about it. But, doing the complaints simple enough. And, well, since we're here, we'll take a look at one. Hang on a second. Okay, well, first of all, and then there was this other way to complain about California judge, court commissioner or referee, right? That this goes to the Commission on Judicial Performance, which isn't the same as the council we're looking at, but they do have the same address. They just have different suite numbers, but they're in the same building in California, right down the hall from each other. So we filled out one of these, and then I said, well, I really want to fill one out and send it to this thing that the Chief Justice is over. And so it looked like this, right? Put her name at the top, Christina Francis, citizen of the United States, right? Put your ID number, claim who you are, and your ID number authenticates who you are, because there could be many Christina Francises, but there's only be one Christina Francis with that ID number. It doesn't have to be your driver's license number. Because I'm a veteran, I like to use my DOD number, right? But you could use Social Security number, whatever it is. They're all numbers that tie that name to a particular, it's an authenticator. I don't know how else to put it, right? Authenticates the name to a legal entity that we're dealing with. So, to the Judicial Council, deprivation of rights under color of law by California courts, public officer imposters. So, This is what it said. Under the case we're talking about being conducted in the Superior Court of California, County of San Diego, by Judicial Officer Earl H. Moss III, is an unconstitutional simulated legal process under color law by malicious prosecution, from which I demand that Judicial Council of California provide my immediate relief and equitable remedy for the damages caused my person or property by the council subordinates. Right? If they're over the administration of justice, then Moss is their subordinate. So, Earl H. Moss III is not the full legal name of any resident of California, United States. That name is not in any official ID of the state of California. They don't use initials, right? Full legal name. Earl H. Moss III did not satisfy the Sixth Article of the Constitution of the United States to qualify as a judicial officer in California. And that's under, Title IV United States Code, Section 101, aka 4 U.S.C. 101, which came from 1 Stat 23, the first law passed by the first Congress after the ratification of the Constitution. It says here's the oath that satisfies the Sixth Article of the Constitution in this form, to wit, I, Robert Allen Rutluski, do solemnly swear to support the Constitution of the United States. Period. That's the Constitution that satisfies the federal government. Now, if your state requires another one, well, that's fine with the federal government. They don't really care, but they want you to do theirs first. Right? So it doesn't matter if they say they did an oath. What matters is did they do the oath in 4 U.S.C. 101? And if they didn't do the oath in 4 U.S.C. 101, then they didn't satisfy the Sixth Article of the Constitution, and they have no authority in the United States. So quit calling them judge. Right? Make them prove who they are. So don't ask them for their oath. You tell them, if you don't have the oath in 4 U.S.C. 101, judge, here's a copy of the law, then you don't have any authority in the United States. That's what you tell the judge. And say, Judge, do you have the oath or not? Right? And don't go anywhere else with any other questions or get pulled off anything until the dude answers if he's taken the oath or not. Maybe you didn't hear me, Judge, for the second time. Did you? Did you do the oath that's in 4 U.S.C. 101, Judge? Yes or no? For a third time, Judge. Who's your third witness? Judge, I need to know if you have done the oath in 4 U.S.C. 101. Yes or no. Let your yea be yea, let your nay be nay, and he will tell you no. But until you make him tell you no, he is going to confess and avoid away and act like he didn't hear you. And move on as fast as he can. Right? Earl H. Moss III is not constitutionally qualified to judge any matter that could adversely affect my life, liberty, or property. Now, understand, I'm not blaming the judge. I'm just pointing out to the judge, Judge, if you don't have this oath, you don't have any authority over me. I'm a citizen of the United States. If you want to have authority over me, you had taken this oath, 4 U.S.C. 101. Didn't do it? Well, then, if you didn't do it, then the plaintiff has brought the case to an improper venue. It's not your fault he brought it here, Judge. It's his fault, but I'm making you aware you don't have no authority. So David A. Kaysen, which is a plaintiff's attorney, is not the full legal name of any resident in California, United States. No. There are no middle initial names on these, real ID compliant IDs. They're all full legal names. That's your identification, right? David A. Kaysen is not anybody's identification. It's a fucking pseudonym. So David A. Kaysen did not satisfy the Sixth Article of the Constitution of the United States to qualify as a judicial officer in California because all attorneys are officers of the court and they do take an oath of office as an officer of the court. Well, if they have to take an oath because the state says so, then they have to take an oath because the federal government said so. And, make them show their frickin' paperwork. So, you're asking for the judge for his judge's oath, ask him for his attorney's oath. He can't be a judge unless he has an oath as an attorney. And I don't believe that they did them. I mean, I've seen them before. They're there, but there's the oath. But I don't believe these people are doing their oaths. So until they prove it, I'm saying I'm being denied justice because these people don't have any authority. It's a simulated legal process under color of law, deprivation of rights. All of these are federal complaints or federal offenses, and I'm happy to call on the Army in a military martial law government to come and take away the belligerents, because they're the ones bringing this crap against us. I mean, they're bringing things to a court that doesn't have any authority to make a decision, and then they're going to coerce you to agree that they have authority. They're taking it to Judge Judy's court. You think it's a state court because that's what you've been made to believe. That's a state court, but it isn't unless the judge has the oath, and he doesn't. So it's not. So call him on it. David A. Kaysen is not constitutionally qualified to prosecute any matter that could adversely affect my life, liberty, or property because I'm a citizen of the United States. I'm protected by the Constitution. Right? And it says you have to do these things. Right? So I'm trying to separate Satan's house. Divide Satan's house. Put the judge against the attorney. Have the judge throw the attorney under the bus for bringing the shit there in the first place. It is a malicious prosecution. And guess what? That's covered under the guy's liability insurance policy. And a per occurrence for malicious prosecution is $1 million. So tell the judge you want damages. But they didn't want to listen. So, hey, here we go. So David A. Kaysen. So, the judge didn't want to do it. Well, now I'm going to go complain about the judge. So here's all the things going on in that case. So David A. Kaysen is not full legal name, a resident of California, United States. David A. Kaysen did not satisfy 6-hour Constitution to qualify as a judicial officer of California. And David A. Kaysen is not constitutionally qualified to prosecute any matter that could adversely affect my life or liberty or property. Now, you understand in both of these paragraphs, you could just replace the names and the name of the state, and it would work for anywhere. Anywhere in the United States, this is good. Right? You just need to, whatever state you're in, resident of Michigan or Ohio or whatever it is, right? And use the style of name that the judge is using on his paperwork or whatever you find it, and the same with the attorney, and tell them, hey, these aren't full legal names. And then find out who administers justice and take it to them. Brixmore Felicita Town Center, LLC, a Delaware limited liability company, that's supposed to be the name of the plaintiff, by the way, does not have any legal standing in California to sue or be sued. It's not listed in the state as, having a certificate of authority to conduct business in California. And in any civil case, whether, showing you this is supposed to be the name of some entity, it's never correct. Right? If you take the name just the way you see it on the paperwork and you go look for that name in the state records to see if it's licensed to do business, it won't be. There may be something close to it, right? But not the way it was put on the paperwork. My attempt to have a hearing on this matter with Earl H. Moss III on 10/14/2020 to give him the opportunity to right the wrong caused by an intentional tort, malicious prosecution, was rejected by him, and instead, by an act of bad faith, he coerced me to accept his personal decision that an ex parte hearing requires all parties receive notice of the hearing and is extorting me to pay his fee again for another hearing. That's what's really happening. Right? They have their story. We have ours. This is our story. The Register of Actions, which is supposed to be the official record of the proceedings, is missing numeric entries that indicate the omission of material facts in a matter affecting constitutional protections. Register of Actions, item 28, contains my affidavit in support. For in order to show cause why the attorney for the plaintiff should not be held in contempt of court for malicious prosecution, and exhibits of evidence that were ignored by Earl H. Moss III. Earlier today, I sent attachment 1 to the Commission of the Judicial Performance. That was the other form we looked at. I am in expectation of quick relief and equitable remedy from the Judicial Council of California, and I am leaving it to the council to figure out how to administer my justice. Now remember, it's the Chief Justice of the California Supreme Court that sits at the head of this frickin' council. So make it her problem. Right? By going to the administrator of justice instead of the judicial office, we're going to the administrative office. Anyway, she hasn't heard on this yet. We just did it a couple days ago, but that was the idea. Let's not just agree to what the guy we're already saying is an imposter is doing anyways. Let's call it what it is and go throw it in somebody's lap. See if they do something with it. Okay, I think that's really all on that one for now. Okay, and I want to show what's going on in New York, so hang on a second. Okay, so in closing on California, it's worth noting, right, that what this minute order is that the guy put in, it's like his self-confession of what he did. I mean, it's all written down here, what he did, and the reasons he did it. And I'm saying, well, that doesn't jive with the definition, so I can complain about it, right? Let's have somebody make a decision, and that's what the Chief Justice needs to do now, and say, well, who's right? And again, so in Michigan, the chief judge, we have a thing called the chief judge rule, and he's supposed to be over the administration of justice in his jurisdiction, right? But I think that the one to go to, because now in Michigan, then you got a chief judge over the circuit court, you got a chief judge over the district court, you got a chief judge over the probate court, right? So which one of those are we speaking of? Well, you could always write to all three of them. That'd be one thing to do. But, if I had to guess, I would say, well, it's the one that has jurisdiction over general civil, because that's what these cases are. They're in general civil. They weren't put in probate court. I'm not saying there aren't things in probate court. I'm saying the civil case was put into the general civil jurisdiction. And that's where felonies are heard and, that kind of stuff. So that judge, he's in charge of the administration of justice. And, so if you have a presiding judge or a chief judge or whatever, they're going to have something to do with the administration of justice down below them. And so don't forget them, right? The chief justice of the Supreme Court, your state Supreme Court, however you call that person's involved, right? They're the chief. There's a reason they're the chief. And you have the same thing at your county level. Get them all involved. Right? Take it to the county commission. Say, what the hell's going on? I can't get any justice. Because they're responsible for funding the administration of justice. Okay, so yeah, this is his self-confession. So, now, what's going on in New York? Where was that? So, I had found the miscellaneous case cover sheet for the Southern District of New York. Has all these boxes you can check, just like a civil cover sheet does. But the things you can check on there all have to do with a court of equity. They're not really things from courts of law. Subpoenas and so forth. I mean, the word subpoena was created by the court of equity. Well, they created the subpoena that we use today. And it was used because it's used to, the court of equity is there to fix the defects in the civil law or in the common law. So in the common law, he who holds the title is the owner. If you had a title to a house, you actually had a piece of paper that said, here's the title. Well, whoever had that in their hand would be the owner of the house. Right? Because it doesn't have anybody's name on it. It's just the title to the house. So it doesn't matter if somebody breaks into your house and steals your title. If they have it, they're the owner. That's how common law works. That's all I can do is say, well, he's got the title. He's the owner. So what are you going to do? Well, that's why you can't go to common law for remedy, because all common law can do is give you damages. Say, well, we can't give you back the title, but we'll make him pay you some money. But what if you wanted the title back? Well, that's why you need to go to the court of equity. which is in personam jurisdiction, which can call that person in who took the title and ask them how they got it. Did they do it by bad faith? And if they did, well, then they can say, hey, that's an act of bad faith. That would be a crime. And, and now that the court of chancery, the king's conscience, has spoken, well, now the king's bench can do whatever needs to be done to give a remedy. Or actually, the chancellor just does it himself, but it'll be backed up by the king's bench. Right? The chancellor can do it all by himself, and it's done by the manner of the civil law, not by the manner of the common law. So it's not adversarial, which is what they have these as, right? It's like ex parte or ex rel, right? In relation of. So anyways, they opened these cases with what I put in, but they made them civil cases, right? And this is one of the things I was complaining about. And if you look at the dates on these, the one with the later court case date was the one I filed first. So they really didn't file this one until after I had done something this week and I sent this letter to them, I think is when they filed it, because all of a sudden about 5 things happened in the same day. And it's just easier to show you when we get there, but because I'm making a public record for NSA, right, the National Security Agency. Hey, there's 2 court cases now in the Southern District of New York. And they've both been given to the chief judge of the Southern District. Sue Sponte. I'll show you that. Here we go. Okie dokie. So, I guess I got 2 different cases now in this court. But the way it happened was this particular case was actually the second complaint I put in, but the first one to be made a case. And then the first one I put in, they just now made a case a couple days ago, and I think it's because of the letter that I wrote to the judge. Although I have no evidence of that yet. It just all seems to fit together, and that's what I'm going to show you. But so I had filed a complaint, and I was trying to put it in as a miscellaneous case. They put it on the civil docket, right? And they said it was the cause was a 28-1331, which is that's the same as saying Title 28 United States Code Section 1331, judicial question. And then the nature of the suit was a civil rights other, and that the United States government was a defendant. Well, that isn't what I wanted. This is the $400 way of, going to court, right? This is a civil case. I didn't want that. I wanted a miscellaneous case. But they had on here, right, that as they were putting these things in, date filed, they got what the complaint came in, and then it was designated an ECF, and a civil cover sheet was filed. Right, but that isn't what's filed. A miscellaneous case cover sheet's been filed. So this is the thing of when they say there's a civil action, that's true. There is only one civil action, but there's 2 kinds of civil actions. There's one done by the common law and one done by the civil law. I want the one done by the civil law. But as you can see, I mean, you look at this form, and I can see where the mistake is. It says defendants. I probably should have crossed that out and put respondent. Right, but it's simple enough. It says a miscellaneous case cover sheet. It doesn't say it's a civil case cover sheet, and they have one of those. So there's really no reason for somebody to put this on here like this, unless they're trying to deny me justice or they made a mistake. So I called them about it and said, hey, they made it a civil case. It's supposed to be miscellaneous, blah, blah, blah. And I'm talking to the pro se office, right? So this is an important thing to know, that under the chief judge is an office called the staff attorney. And under the staff attorney are these people that work in the pro se staff attorney office. But it's a separate avenue to the court outside of going to the clerk. Because what they tell you to do when you're filling out your paperwork pro se in the District of New York, the Southern District of New York, is you're supposed to send it to the pro se office first. Well, I don't know anybody that, I've looked at paperwork filing it into federal cases that I've taken it to the pro se office, right? It's going to the clerk. So we're trying to file it like an attorney instead of trying to file it like pro se. Now, they may not make this really clear to you, but, I'm telling you, that's what's happening. And, so it's much more clearly written, the process in the Southern District of New York than it is, let's say, the Western District of Michigan. But when you get right down to it, there's 90-some districts, right? And I'm sure that if you were to go look at all of them, by the time you got done, you would have the whole picture. Like, got some over here, some over there, some over here, da-da-da-da. Right? But here's, this is a big thing here, is getting it from the civil docket to the miscellaneous docket, right? That would be the first thing, because the civil actions are in civil law is how equity is done. And, right, the chief judge is acting as like the chancellor of the district of territory they're over. So they're the king's conscience, basically, for that piece of the territory. So that's what we're trying to get to them as. We're not trying to sue the United States. We're trying to say, look, king, this has happened, and, you need to fix it. Your officers have harmed me. And back in the day, it was called a pleas of the crown, where you would petition the king to say, your officers have done me wrong. This is what they did. And the king would have a duty to correct the errors of his officers, right? So give you a remedy, then he'll deal with his officers as needed. So that's this, right? Hey, you put it in the wrong fucking file. I don't need to put up with that. I'm going to complain about it. Right? No, I didn't put it in a civil case cover sheet. I put it in as a miscellaneous case cover sheet. I called and talked to them. They said, well, then what you need to do is you need to write the chief judge and complain about what happened. You say, okay, well, I've done that before. No big deal. But they said, but you have to send it to the pro se attorney's office first. So, right. So that's not what we're doing. I mean, I've never filed any paperwork into a pro se attorney's office. I didn't even know they existed until I came across this here recently. Or if I did, I didn't, put two and two together. But it's really clearly written in New York that, your paperwork goes to the pro se attorney's office first. Which is what happened. And hang on, let me show you the letter real quick. So I ended up writing to the chief judge, like they said, and I'll explain how I did it here in just a second. But as you can see, they put a received stamp on it for the pro se office. I've never had that before in a document. So, received has a particular meaning in law, and it's like voluntarily accepted or something like that, right? But anyways, when I was talking to them, they said to write a letter to the chief judge of the court. Now, I had in my previous studies had seen that, with the post office, that it's the letter that has to have the postage on it. You're not paying for the envelope, you're paying for the letter. And so if you go back far enough, you can say, well, that's really the stamp tax, which says you had to have the stamp of the sovereign on your paperwork to submit it into a court case. Right? So, okay, I'm going to put a stamp on, a first-class stamp. I'm going to cancel it by scribbling through it. That's how you cancel it, with black ink. And call it a prepaid first-class letter and use my 11-digit zip code, which, because I live in a private residence, right, single-family dwelling, it's the last two digits of your house number make up the last two digits of your 11-digit zip code. Otherwise, you have an apartment number or something like that. But for us, they call it the unit number. Right? If you own a house, your unit number is the last two digits of your house number. And that is they have a name for it, your delivery point, right? Which is a unique address, one of a kind, anywhere in the world. Right? So there's only one of those. So that's your address, right? This is like authenticating your name. This is authenticating your address. So I don't know if that means anything to these people or not, but I know where it came from. I read that shit. So I'm going to go ahead and put it on paper. Right? Returned, Robert Allen Berlusky, right? That's who it's from. And who's it to? The United States District Court Chief Judge Colleen McMahon. Miscellaneous case petition in equity mischaracterized as civil case 120 CV 08543-UA. Chief Judge, I intended to file a miscellaneous case into the equity jurisdiction of the United States District Court, inherited from the Circuit Court of the United States under the Judicial Code of 1911. As there is no miscellaneous case cover sheet available for the Western District of Michigan Court, I decided to submit my petition to the branch of the United States District Court you preside over. A court employee either made a mistake or abused their authority and changed the nature and cause of action from a non-adversarial civil law style to non-criminal adversarial common law style, then docketed it on the civil case docket instead of the miscellaneous case docket. They even altered the name of the court to the U.S. District Court, right? U.S. District Court, and the name of the party to Robert A. Berlusky, as is evidenced by enclosure 1 of this letter. The name has since been corrected. It was one of the reasons I had called. They had used my middle initial name in a document. An act to regulate process in the courts of the United States, would be September 29th of 1789, mandates the forms and modes of proceedings in causes of equity and ability in maritime jurisdiction, A, shall be according to the course of the civil law. So it's not common law, it's civil law. It's non-adversarial. It is not my intention to charge the United States in a court of law adversarial proceeding, but instead to have a hearing on the merits of my grievance by an agent, the Chancellor of the United States, empowered to right any wrongs caused by administrative errors or omissions in official records of the United States and compensate my damages. Historically, such an action may have been known as a pleas of the Crown and heard in the Court of Chancery by the Chancellor, a.k.a. the keeper of the King's conscience. I believe that the United States District Court represents the keeper of the government of the United States, the government of the United States conscience, and is the proper trier of the adjudicated facts, possessing both power and authority to inquire into the matter and provide the complete remedy and equity that is not available to me in law. Right? I need more than law can give me. I have to have equity. Chief Judge, I believe that access to the court's equity jurisdiction requires a miscellaneous case, but regardless, I am asking that you hear my petition in the Court of Equity. Thank you for your service, Robert Allen Berlusky, Staff Sergeant. And then I put this P.S. P.S. One of my petitions was converted to this case we're talking about, but the other one I submitted on 10/6/2020, which was 10/8. Now I'm going to go back and look. Has yet to be categorized and appears to be missing in action. Please have a hearing on this matter of national security as soon as possible. Okay, so anyways, what did I have to say here? I'm saying that, somebody changed the nature and cause from non-adversarial civil law to non-criminal adversarial common law. That's what a civil case is in common law. When you go have a civil action in common law or in a court of justice, they're doing it, by an adversarial common law style, where the judge just acts as a impartial referee. But in a civil law, non-adversarial case, the judge is the one asking the questions, right? They're inquiring into the matter. And that's what I wanted them to do, inquire into the matter and get a solution and, give me my justice. But they sent a thing with Robert A. Berlusky. That was the first thing, right? So there it was. Pro se consent to receive electronic service. The following party, Robert A. Berlusky, consents to receive electronic service. Right? In the U.S. District Court, Southern District of New York. Well, I thought it was the United States District Court. What happened to the name? Right? Well, I know what happened. It's because we're under martial law. So this is the one pretending to be the United States District Court, right? Doing the functions of the United States District Court. But it really isn't the United States District Court because there's no Article 3 judges. Right? We're under martial law. There's nobody in the judicial branch. They haven't taken the oath to satisfy the 6th Article of the Constitution. So we don't have a civil law, a civil government. We may have a military government, and that is what we have. We have a military government. They're just not telling us that. But if it's a military government, then as a veteran, I have special status. So I'm claiming it. I just got to get them to acknowledge it, but that's the idea. And then I sent basically my first complaint again, and they actually entered it into the court case, and then they made a court case out of it. So I want to read this one again because, this is the one that, actually I'm going to read both of my complaints now. That's what I want to do. Finish up my public statement for the day. So my original complaint to the mother court was this, that petitioned the government for the redress of grievance. Government of the United States is not enforcing the fundamental law of the United States. For the people of the United States, I, Robert Allen Bretlewski, a citizen of the United States and a veteran member of the Armed Forces of the United States, attest that the government of the United States is not enforcing the Constitution of the United States of America, ordained by the people as the fundamental law of the United States, and entitled Constitution of the United States. Right, so its title is the Constitution of the United States, but it's the Constitution for the United States of America. That's King George's jurisdiction. It's what them fucktards have to follow. And they ain't following it. Right, because in the Republic, we don't have a president. We're self-governing. But the United States of America, which is allowed to exist as part of the treaty, it's King George's jurisdiction, which got a president to keep them people in line. But what they're doing is making sure that the guy who's supposed to be the Article 2 president isn't taking the oaths required to be the president. And therefore, they don't have a president, so we don't have to listen to nobody. That's how their shit works over there in the democracy. And they're all running amok, right? And that's in the Washington, D.C. So anyways, that's why we need Donald John Trump to redo the oath in Article 2. Go listen to what Esquire John Glover Roberts Jr. did. He said, I, Donald John Trump, and that isn't in the oath. Right? That's what Roberts led off with, and then he ended with, so help me God. So he added a religious test to the oath that he was given to Trump. So it's all fucked up. Got to all be done over. And then while you're at it, do the oath in 1 Stat 23, sir, and you can be the President of the United States, as it says in Article 2. Let's continue. We'll get to that in a minute. So, because, that's at the big end. This problem goes all the way down to your dog catcher. The United States and several states' alleged public officers are knowingly or not imposters because they have not executed the oath of office mandated by Congress that satisfies the 6th Article of the Constitution of the United States. These persons, knowingly or not, are in violation of Section 912 of the United States Code, Title 18. That'd be 18 U.S.C. 912, right? They're imposters of frickin' officers of the United States and are warned with the Constitution of the United States because they didn't take the oath that's in Article 6 or not to satisfy Article 6. Let's see where that came from. It's all written down. I mean, this is, just stepping through the procedure. Per the 6th Article of the Constitution of the United States, the senators and representatives before mentioned and the members of the several state legislatures and all the executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Now, do you understand, until they have satisfied that section of the Constitution, whoever it is has absolutely no authority over you. And if you didn't know that, you need to, and you need to tell them you haven't taken an oath to satisfy the 6th Article, fucktard. You ain't got any authority. right? And, let's get it decided now. Did you or not? So, an act to regulate the time and manner of administering certain oaths. That'd be 1 Stat 23, signed by President George Washington on June 1st, 1789, mandates in its first section, being enacted by Senate and House of, in brackets, representatives of the United States of America, right? Not of the United States, of the United States of America, King George's jurisdiction, in Congress assembled, that the oath or affirmation required by 6th Article of the Constitution of the United States shall be administered in the form following, to wit, I state your name, do solemnly swear that I will support the Constitution of the United States. Period. Right? Shall be administered in the form following, to wit. You don't get to add to it. You don't get to throw it in the middle of your state's constitution. You do this one because it's an act of Congress told you to do this one. Well, they're not doing it. So in Section 3 of this act is declared, members of the several state legislatures and all executive and judicial officers of the several states, like your governor, attorney general, secretary of state, fucking circuit court judge, chief justice of your state court, them people, right? Those people who shall be chosen or appointed after the said first day of August shall, before they proceed to execute the duties of their respective office, take the foregoing oath. Right? When did it say they had to do it? Before they proceed to execute the duties of their office. So they don't have any authority over you until they've taken the oath. So they may have authority over their own little clique of people in their society that they created, because that's what the bar is. It's a voluntary society. You have to volunteer to be part of it, but if you do, you're bound by its rules. So, they want you in that jurisdiction as a mister, with them being esquires. And we want to say, no, I'm a citizen of the United States. I'm not in that jurisdiction. You have to have this oath before you have any authority over me. I'm self-governing. And let them deal with that. Continuing on. This mandated oath was incorporated in Article United States Code 4 U.S.C. 101. Just Google 4 U.S.C. 101. Oath by members of legislatures and officers, specifically addressing the state officer's duty to execute the oath prior to exercising the power in office. And according to the 6th Article of the Constitution of the United States, this Constitution and the laws of the United States, which shall be made pursuant thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. So if that man or woman sitting there tells you they want to be a judge in your state, then they have to do what the Constitution and the laws of the United States says, or they're not a judge in your state. Well, the law says they got to take the oath that's in 4 U.S.C. 101. Right? The alleged public officers of the several states are in violation of this Constitution and usurping authority of public office for not first having qualified for office by executing 4 U.S.C. 101, because that's the oath that satisfies 6th Article of the Constitution. Right? They violated it. As a result, the states are denied the Republican form of government guaranteed by the Constitution of the United States. Oh, no, that's a big fucking deal. Well, now it ain't about me. It's about the state, right? They denied the state the Republican form of government by not taking that oath. Article 4 of the Constitution of the United States guarantees every state in this union a Republican form of government and shall protect each of them against invasion and an application of the legislature or of the executive when the legislature cannot be convened against domestic violence. I'll use Michigan as an example how the government of the United States broke its promise. So under the Freedom of Information Act, I requested the oaths of office officially recorded by the alleged governor of Michigan, Gretchen Whitmer. What I received in reply was not the oath found in 1 Stat 23/4 U.S.C. 101, nor was it the oath of office required by the Constitution of Michigan of 1963 or any previous version of the state's constitution. Gretchen Esther Whitmer, aka Gretchen Whitmer, is unqualified for the office of Governor of Michigan because she evaded executing the oath that satisfies the sixth article of the Constitution of the United States. Right now, it's not just her, it's yours too. Anybody's governor, they all have done the same thing. They're all as guilty as sin of the same bad faith act. She also counterfeited the oath required by the Constitution of Michigan of 1963 by filing with the Michigan Department of State, because she did file a piece of paper, a document with an altered oath text, subscribed under the nickname Gretchen Whitmer, and witnessed by a class of state officer unauthorized to administer an oath to the office of governor. I mean, it's just not one mistake. There's at least three. Exhibit 1 is my request for the oath in the state's reply, right? So, Freedom of Information Act to your Secretary of State, telling you want the oath of your governor, they'll send it to you, and it will be wrong. And it won't be the one in 4 U.S.C. 101. In fact, you can put in there, and please include the one for 4 U.S.C. 101, and then they'll have to address it and say, this is the only one we have, or whatever it is. But I asked for oaths, and I got the one they gave me, so I say, well, that's the only one she's got. And it's not the oath of 4 U.S.C. 101, and it's not really the right oath of the Constitution of Michigan, because they changed the frickin' capitalization of the text. So they changed the grammar. So Imposter Whitmer is not alone in the impersonation of a public officer in Michigan. Requests for other state officers' oaths leads to the same result. Again, so it's not just the governor, it's any person in all the way down to your township commissioner, or township supervisor, or clerk, or dog catcher. Anybody who's claiming authority as part of the government in your state has to take the oath that's in 4 U.S.C. 101. Right? If you're taking the oath that's in your state's constitution, then you need to take the oath that's in 4 U.S.C. 101 separately and using your full legal name. And if you haven't done it, then you don't have any authority in the United States. And you're just going to have to cease and desist. Imposter Whitmer is not alone in the impersonation of a public officer in Michigan. Request for other state officers' oaths of office leads to the same result. No person claiming an office authorized by the Constitution of Michigan of 1963 has filed a federal oath of 4 U.S.C. 101 or executed a valid state constitutional oath. As a result, the state is denied a Republican form of government guaranteed by the Constitution of the United States. It is my belief none of the several states have qualified public officers for a Republican form of government. They can't, comply with the Constitution. Well, then it's time to defend the Constitution, Army. This constitutional crisis is not limited to the several states. The president-elect, Donald John Trump, has been denied the Article 2 oath of office. Article 2 office of President of the United States of America because Esquire John Glover Roberts Jr. incorrectly administered the Article 2 oath, added Donald John Trump and religious test to the president-elect, requiring a redo of this oath. It's really that simple. Donald John Trump must also execute the oath of 1 Stat 23. Well, yes. Why? Because he's the chief executive officer and a commander-in-chief. Well, those are executive offices. Alleged senators and representatives did not comply with Article 6 of the Constitution of the United States. Instead, they execute false oaths that contain the religious test, so help me God, subscribed using a pseudonym or nickname that was filed in a manner contrary to law. Exhibit 2 are some particular pages of the House section of the Congressional Record for a particular date, which would be January 17, 2019. This record shows that the alleged members of the House of Representatives filed documents after the adjournment of the day as oaths of office of a representative. They waited till they were done and say, well, here's our oaths, right? Now, they're supposed to do this like on the first Tuesday of the session. They're doing it on the 17th, so, it's all wrong. Just all wrong. and also for access to state secrets using a false identification on a color of law simulation and legal process for the act, 1 Stat 23, required to be performed. In other words, they're supposed to do 1 Stat 23. They didn't. They just pretended on some other paper. It's all a simulation of a legal process. And it's an evasion of an oath required by the Constitution. The judicial branch of the government of the United States has been abandoned and no Article III judicial officers exist. Persons claiming to be a federal judge did not execute the oath of 1 Stat 23, swore an oath with religious tests, and do not have a valid commission issued by the President of the United States of America under the Great Seal of the United States delivered to said judicial officer. In other words, things were just never quite completed. They never finish anything, and they never do it right. Executive branch officers file a document entitled Appointment Affidavits, not an oath of office. The filing of this appointment affidavit simulates a legal process under color of law and causes the deprivation of rights of a citizen of the United States. Yes, it does. It does not contain the form of oath required by 1 Stat 23. And it bifurcates the oath found in 5 U.S.C. 3331, which itself is unconstitutional because it contains a religious test. There's nothing done properly. As a result of a scheme by conspirators warring with the Constitution of the United States, there are no qualified officers of the United States to enforce its laws and Constitution of the United States, leaving the citizens of the United States and states are denied a Republican form of government guaranteed by the Constitution. In actual fact, as the requirement of Article 2 of the Labor Code of April 21st or 24th, 1863, also known as General Order number 100, has not been complied with, the United States has been under martial law since President Lincoln declared the same in 1861. The display of the gold fringe flag in the United States is controlled by Army Regulation 840-10. You should probably remember that and go get a copy. And this regulation makes no provision for this style of flag to be displayed by the civilian government. You'll find it in Chapter 2, Section 3. It is this flag, gold fringe, that is displayed in courtrooms and offices of the government. As long as it remains on display, it is evidence that the United States is still under martial law military rule, and that the courts, including SCOTUS, are military tribunals, and not courts of civilian government under the Constitution of the United States. If you look at a picture of the SCOTUS courtroom, it's got these two big-ass gold fringe flags flying out, just as big as can be. It's like, well, I can read where it says those only go in, military tribunals. So apparently that's a military tribunal. Well, if it's a military tribunal, as a veteran, I'm going to claim the right to trial by court-martial. And according to 10 U.S.C. 246, anybody between the age of 17 and 45 has a very good chance that they're in the militia, and they have right to trial by court-martial. So demand right to trial by court-martial. And they'd have to stop the proceedings. Because no one's going to swear to what they're doing to you, and that's what happens. See, under trial by court-martial, your rights to due process are protected. Now, they should be protected under the Constitution, but the Constitution's been suspended because we're under martial law. So now, you want to have your rights to due process protected, you have to have a court-martial. So, instead of taking you to a court-martial court, they're taking you to a provost court or some other military tribunal for unprotected belligerents during a time of war. If you were a protected person, such as a POW, you would be having a trial by court-martial. And that's not what's happening. Although the court can do it because there's a gold fringe flag. So, until we get it all figured out, I would, that's what I'd be telling them is I demand trial by court-martial. Tell the judge that. Say, Judge, do you acknowledge that I demand trial by court-martial? Make him say yes, he acknowledges you've asked for trial by court-martial. And then give an answer. But what they like to do is act like they didn't hear you. And we only ask once and move on. You can't do that. You got to get them to say yes. Right? We're trying to get consent. Right? Want everybody to acknowledge, what rules are that we have in this particular proceeding. Okay, so the United States is at war. Did you know that? If you didn't, well, it is. The United States is at war, and persons claiming authority under the United States that conceal their full legal name identification on a simulated legal process they submitted as an oath of office are to be considered spies and saboteurs until properly identified and empowered by the United States Army to be a member of the wartime government. Right? Because they'll still be in a government, it'll just be run by the Army. They won't be people in the Army necessarily wearing the uniform. Right? They'll hire that shit out. That's what they do. Right? They'll give you a commission to go do business for the Army. But the government is a military government. As there is no functioning Congress of the United States, the imposters in the Capitol building must be captured if possible, killed if necessary, but in any case driven out of the United States. Yes, that is said in a court case in the Southern District of New York. Do you think they're going to come put me in jail? I don't believe so. Congress impersonators are enemies of the United States, and I demand they be removed from the Capitol and that the United States Army do what is necessary to install Donald John Trump as Commander-in-Chief so he can end the Civil War and restore civil rule to the nation and all other relief the United States Army can provide. That's what I was looking for. Now, whether we go back to civil rule right away doesn't matter to me. What I want them to do is recognize me as a veteran as part of the government and give me my ID card and give all the other veterans their ID card and kick them people out of the Capitol that are pretending to be the government because they don't have an oath of office. Anyways, this is the oath they put in for Michigan. And I like to show this, right? Because this is all they did, right? Constitution of the state, that's supposed to be a term. Well, they capitalized the C and the S on here, but in the state's constitution, it's a proper or a lowercase c and lowercase s. So they changed the meaning of the oath, and she didn't use her full legal name, and it was done by a notary. And a notary public is not authorized by state law to administer this oath to the governor. That'd be an MCL 1537. Right, so it's a simulation of legal process. Non-constitutional oath of office. That's wonderful. All this stuff is now in a court case. Actually, it's in 2 court cases. Because I sent this as an attachment saying, hey, they never put this in the court. Would you please put it in now? And they did. Right, under this original court case number. But now they've opened up another court case just for this. Both under the chief judge right now. It's a wonderful thing. Right, but this is the crap they do. And so I should, if I'm going to have it on here, I should stop to talk about it. So here's the oath of office, right? First of all, here's the adjournment for the day. Now we're going to say we did this particular oath of office. They say satisfies 6th Article of the Constitution. But it doesn't. What's in 1 Stat 23 satisfies 6th Article of the Constitution. It says so. This doesn't. And this has got a religious test, so help me God. So it's already unconstitutional. Lie, 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 lie. And then all these people are using a fictitious form of their name, not the name that's on their driver's license. It's not their identification. Right? So they're going to all pretend to become a representative of their state, and then they're all going to take another oath to get access to classified information. Well, that makes them a spy. Army. And here's the evidence, right? Stephen M. somebody. I'm afraid that's nobody's full legal name. So that's that. Hang on a second. Okie dokie. Talk this long. I'm going to talk a little bit more. I want to finish my public statement, but I want to point out, I think that this is what you need to have on your paperwork if you're filing a case into the federal court. You need to send it to the pro se office. And this is all If you go to the Southern District in New York and look at everything they have to do that says what pro se, right? That's where I got my feelings from, that's what all that means, and that's why I'm trying to do it this way. But I'd never had this before, where they put this uh, stamp on it. And the way it works, it goes from the chief judge down to a guy called the staff attorney, and under the staff attorney is the pro se staff attorneys and the pro se office, right? And it has nothing to do with the United States attorney, right? Actually, the guy that's the staff attorney, when you go read what it says about these things, they're giving legal advice to the court, right? He is the attorney for the United States, or the United States lowercase attorney. Right? I'm saying, well, that must be like, because it has to be a guy learned in the law. Well, that's what they say about the guy that is the, Solicitor General. He has to be learned in the law. Right? So solicitors are judicial officers in courts of chancery, where, an attorney or a lawyer is a judicial officer in a court of law. But we want to be in chancery because that's where equity is. Right? So it's just the other door to the court. I mean, that's what I'm hoping it is. And that's why I'm doing it this way. Okay, so that was the first complaint I put in. That kind of sat there. Nothing happened. It didn't actually even get put in until the 22nd. The day that they put this answer in is the day they put my first complaint in. But my second complaint, because I just, what I wanted to show is this right here. Right, this is the miscellaneous case cover sheet. And you can find this, if you Google miscellaneous case cover sheet, it'll come right up. It's from the Southern District of New York, right? SDNY. And like my state doesn't have one. So, but if the United States is a district, right? Because it is, I mean, it's a territory. So it's a United States district. Then it could have a court over the whole United States. That would be the Superior Court or the Supreme Court, right? That's something that had jurisdiction over the entire thing. And so I say that all these United States district courts, they're all just doorways into the big court. And this particular one in the Southern District of New York, right, is the one that has expertise in using miscellaneous cover sheets. So I should be able to take my business to them because that's what they deal in. Now, that's how I justify doing it. But the thing to do is probably call the chief judge's office of your district court and ask to talk to the staff attorney's office. Because it's the staff attorney's office that all this stuff is being run through. Right? So I don't even know how much the chief judge's staff would know about it because everything is so compartmentalized. But somebody has to know how to get to the staff attorney because it's an office they have at the court, and it's the guy that gives legal advice to the court. Right? So it's not the U.S. attorney, it's somebody else. Anyways, so they have this form to fill out for, miscellaneous cases. And if you were to look at all the things on here, subpoenas, this is where habeas corpus comes in, right? Orders to stay, applications, all things that you need that can't be given to you in law, because all law can give you, the only remedy law can give you is damages, and that's money, right? They can't reform a contract or things like that. That's what equity does. And so instead of me trying to pick, well, which one of these do I need? Because these are all like specific things. I say, well, let me go to other, and I'll just say it's a petition to government for redress of grievances. Right? So that's how I'm using the form, is to say I'm just going to petition the government for the redress of grievance. I'm going to tell the judge my problem and let the judge figure out how to take care of it. He can figure out which one of these things are necessary to, take care of the problem. And he can get that answer by going and talking to the staff attorney, right? So the other option is, well, I could talk to the staff attorney first and tell him what I want to do and see if he can tell me how to handle it, right? He can give me legal advice. Because he's the attorney for the United States. I'm a citizen of the United States. Give me some advice. Haven't gotten there yet, but these are all things that I didn't even know these offices existed a couple weeks ago. So, okay, I want to take just a minute and read this complaint I put in for veterans, right? So if you're a veteran, or a veteran, or a survivor who doesn't even know they have benefits coming to them, right? This is really for all of us. And this is how it works. So there's errors in government records in the United States causing deprivation of rights. Right? I, Robert Allen Rutluski, DOD number, attest to the following statement. There are various administrative errors and omissions in official records of the government of the United States that are adversely affecting my affiliation and eligibility for benefits pertaining to my honorable and faithful service in the United States Army. Administrative errors in my defense enrollment eligibility reporting system record are keeping me from obtaining the identification card mandated by the Geneva Convention that I be in possession of, pay other entitlements and privileges owed me under the enlistment contract between the government of the United States and myself. Yes, we have a contract. And they did sign it. Right, that's one of the few contracts where the other side signs the contract. According to the Department of Defense Manual, number 1000.13, Volume 1, Enclosure 2, ID card, life cycle procedures, identity, and eligibility verification, C, DEERS verification, the VO shall utilize DEERS to verify affiliation and eligibility for benefits as described in Volume 2 of this manual. All right, you want to have any benefits from Volume 2, it had to be in DEERS. All right, it is my belief that utilizing DEERS information, the VO, should issue me a DD Form 2S, RET, retired, because I'm over 60. If I hadn't been over 60, they have a different one. RES, reserves. Armed Forces of the United States, Geneva Conventions Identification Card, retired, blue. Right? But here's the important thing. It's the Armed Forces of the United States Geneva Conventions Identification Card. That's the part. The Geneva Conventions Identification Card is what would give you authority in a military government in the United States. Described in Appendix 1 to Enclosure 2, ID card descriptions and population and eligibility categories. They got these long-ass names for things, but it's really just Volume 1 and Volume 2 of DOD Manual number 1000.13. And then according to MilConnect website, right, veterans must be in DEERS so they can register for DS Logon and utilize the eBenefits website. So before you could start using the things online, you had to have this DS Logon, and to get the DS Logon, you had to be in DEERS. Well, I got a DS Logon, so, obviously I'm in DEERS. So I am registered for a DS Logon, but my profile on VA website has my name as Robert Allen Rutluski. Yes, it does. It has it twice. Now, it used to say Robert A., middle initial, Rutluski, which I complained about for over a year and a half, and they finally changed it, and they made it Robert Allen Rutluski. An incorrect date of birth, 9/1/58, should be 9/5, and service dates that are not the same as those on my certificate of release discharge from active duty. Exhibit 1 is a copy of my profile page on VA website evidencing the errors. I believe these attributes in error are incorporated into my DEERS record and contribute to the disenfranchisement of my entitlements. I take notice, by the way, I have a given name, Robert Allen. I do not have a middle initial. Now, there's a form called the DD Form 1966, which you can download. If you're ever in the military, you should. It was filled out by your recruiter. They did all the paperwork back then in the day. I'm sure that, we signed it, but they filled in all the blanks. It's a DD Form 1966. And you'll see on there that they get you to certify that your name, in my case, is Robert A. Rutluski with a middle initial. Now, Elsewhere on the paper, they have me certify my name is Robert Allen Ritluski. No middle initial. But there's a section in there where they make you certify that you have a middle initial name, and this is why they can use that pseudonym for you while you're in the military. Right? You're serving under a fictitious name. I think that's under Title 10 United States Code, Section 1551 or 1552, something like that, that talks about if you served under a fictitious name in the military, you can have your records changed. And I actually did that. And they actually changed my name on my DD or on my first discharge document. Where I had my name backwards, Ritluski Robert Allen, and I said, that's not my name, it's Robert Allen Ritluski. I just said it was wrong. And they changed it. But, you know, the other thing is they give you this, at the time I didn't know about 1966. Well, after seeing that, look, they make you certify that your name is middle initial on that document. So that's an error. You may have made it because you agreed to it, but it's still an error. So that's what we're trying to do is get the errors fixed. Anyways, back to the letter. Right, back to the complaint. Exhibit 1 is a copy of my profile page. Right, evidence of the errors. I believe that contribute to the disenfranchisement of my entitlement. Because both DEERS is used by both the VA and the Department of Defense for your pay, entitlement, privileges, benefits, so forth and so on. They use the same record. The certificate of release of discharge from active duty, DD-214, I was provided by the United States Army, was not executed in accordance with the Army regulation, and it contains administrative errors and omissions that contribute to a mistake in my current status with the government of the United States that adversely affects pay, entitlements, privileges owed me for my honorable and faithful service. The separation authority, that'd be Army regulation on mine, AR 635-200, listed in Block 25 of your DD-214. So whatever's in Block 25 of your DD-214, right, the separation authority. Just go Google it and you can download a copy. It'll be some kind of regulation or whatever. Anyways, it mandates the process that must be executed if I was released from the custody and control of the United States Army. The government of the United States has not provided proof this process was completed. I never received an administrative separation order required under AR 635-200. Yes, it says I'm supposed to get an order. Nor the separation pay authorized by Separation Code JBK, which is in Block 26, I am entitled to, if I had an actual fact been released from the custody and control of the Army. Right? Because my code has a separation pay multiplier on it. I did not sign my DD-214 indicating that I was in absentia, but this error was never corrected by a subsequent document, which it says in AR 635-200 had to happen. And I did not receive my dental exam. As I did not receive a dental exam, I could not have been discharged because your dental exam is part of your military exam before you can be discharged. And they do all this shit on purpose. Right? They have a place on a DD-214 that says, did you have a dental exam, yes or no? And almost everyone I've ever seen says no. Now, why is that on the DD-214? Right? Out of all the things they could ask on a DD-214, why does it matter if you had a dental exam or not? Right? Well, I'm telling you why. Because it's part of your medical discharge exam, and if you didn't have it, you were never discharged. Right? Dental in the Army is part of the hospital. It's just, part of your health care. Right? It is my belief I was never discharged and that the government of the United States exercised its contractual option to retain me past my enlistment date, and that in actual fact I am still a member of the United States Army, even if that would mean that I am considered missing status. The re-enlistment document, Armed Forces of the United States, DD Form 4, that's the enlistment contract, states in its Section 9, Part 5, entitled to receive pay, allowances, and other benefits as provided by law and regulation. While enlisted, And in Section 10, it clearly stated that my enlistment can be extended without my consent. It's all right there on the form. That's the agreement that both the government of the United States and you, Mr. or Mrs. Enlistee, signed. The governor, officers, they got their own gig, right? They had their own deal. But this is our deal. I believe the policies and procedures of the Department of Defense, Department of the Army, and Veterans Affairs are not being followed by the book, and I am unjustly denied pay and entitlements, privileges owed me by my enlistment contract with the government of the United States. In a nutshell, that's the biggest thing, right? Who's ever doing this isn't doing it by the book. And because they're not doing it by the book, they're putting an error in a record that causes us not to have advantage of something we should have advantage of. So I am being paid right now like I'm still in the military, but it isn't coming to me. It's going into some fund, and somebody's living off the interest of that fund. Now, that is how they do it for veterans. If you look at if you Google Veterans Retirement Fund, you'll see that there's, I think it's 2018, they did an audit, and it talks about it's in there. And I did some videos quite some time ago on it now about it that, it shows there's over $1 trillion in this veterans fund. But it's money that should have gone to a veteran, right? It's not money to pay a veteran in the future. It was money paid to a veteran that wasn't claimed, and so it goes into this fund. It has $1 trillion in it, right? That's our money. That's veterans' money. Now, how it got there and by what scheme it ended up being there, that's somebody else's business. But if I can untie the scheme and say, well, no, that's mine, they have to give it to me because it's already been paid. And that's all in, it's all in Title 10. I don't have it in front of me, but, we get that far along, I'll go find it again. But that's the truth for us veterans, right? That this is how they fund their dark side economy is off of our acting like we're still in the military being paid. But they don't give us an ID card. And so they act like we're missing. And a lot of people's DD-214s, they say that they went on leave or they, went into the reserves. It doesn't say anywhere on it they were ever discharged for anything. So a DD-214 is not a discharge document. Right? So if you're a survivor, right, you need to know you got stuff coming to you. I don't know how to get it yet, but, it's in the book. We just need to figure out how to get the book straightened out. So I believe the policies and procedures of the Department of Defense, Department of the Army, and Veterans Affairs are not being followed by the book, and I am unjustly denied pay, entitlements, and privileges owed me by my enlistment contract to the government of the United States. So say I. I believe all veterans and survivors have similar defects in DEERS and DD-214 records, causing them the same style of deprivation of rights. Okay, now this is important to know that in Title 50 of the United States Code, Chapter 50, Service Member Civil Relief, Section 4012, it says that certificates of service, persons reported missing, makes provisions for the Secretary of the Army to provide a certificate by application that would certify my current status. I asked the court apply for the certificate on my behalf, and based on the certificate's details, the court ordered my equitable relief in accordance with the details on the certificate of service. All right, let's just go to what the record actually says and use it as our starting point. And so just really quickly, so if you are a veteran now, and you have this, you know what I'm looking at, right? What does yours say? What does your profile say? Mine used to say Robert A. Rytlewski. And I complained about it for a year and a half. They said, you want to change DEERS, you got to write a letter and so forth and so on. Couldn't do it over the phone, had to write to a certain office. I did. I said, hey, this is wrong, and so is my birthday. So I went from Robert A. Rytlewski to Robert Allen Rytlewski. And truly, this is the government. This is on the VA website. And they have my birth date as September 1st, and it's September 5th, 1958. And my ending dates on my service are different on my DD-214s, I have two of them, than are on this right here. So it's like, this is not my record. If you're saying this record is correct, then it's not mine. That's what I'm saying. All right, because I'm saying this record is, if it's supposed to be my record, it ain't correct because that isn't my name. It doesn't have my birth date, and it's got my dates of service wrong. So let's fix it. Now on your DD-214, because they're all different, they filled out differently. Right, someplace like on my time they put dental care was not provided. Now they actually have a box, yes or no, they check. Right, so they've changed these over time. But there's a regulation, or because in the Army they're all called regulations. I don't know what they call them in the Navy and so forth. But how that stuff needs to be filled out is all written somewhere. How to do the DD-214s, where the information comes from. But as you can see down here, it gives a separation code, right? So whatever that says, if you Google that, you should be able to find the document and then read the document to see if they did it right. And you'll find out they didn't. On mine, because it says Army Regulation 635200 Chapter 4, there's a couple of caveats or footnotes on it, right, that would say that because I have a GBK that I have been barred from reenlistment. It doesn't say why, it just says barred from reenlistment. But I have a reenlistment code at RE1A, which means I could have been reenlisted at any time. Right? So this is the separation code that they talk about from back in the day that has these bad connotations to it. But one of the things that JBK has tied to it is it has a separation pay attached to it. And I never got separation pay. Right? This is the things I'm saying. I've said this to the Army. I've said it to the VA. I've tried all sorts of ways administratively to take care of it before. So now I'm going to take it to the court, but not try to sue the United States, take it as a petition the government for redress of grievances and say, Chancellor, you represent the government. This is the crap that's going on, right? It's errors in records. Please fix it. Now, this is Title 50. United States Code, Section 4012, Certificates of Service, persons reported missing, right? This is good to know because this is prima facie evidence. In any proceeding under this chapter, a certificate signed by the Secretary concerned is prima facie evidence as to any of the following facts stated in the certificate. That a person named is not, has been, or has not been in military service. That the time and place the person entered the military service. The person's residence at the time of the person's entered the military service. That'd be good to know. I don't know what my residence address is. No one will tell me, but apparently the Secretary of the Army knows. The rank, branch, and unit of military service of the person upon entry, inclusive dates of the person's military service. The monthly pay received by the person at the date of the certificate's issuance, right? So if they issue the certificate and it shows I'm being paid, brother, then I'm being paid. Let's get the certificate. And then, unfortunately, I got this sitting on top of it. It's kind of hard to read. It says the time and place of the person's termination or the release from military service or of the person's death during military service. The military, you're not dead till the military says you're dead as far as they're concerned. It doesn't matter. You got a death certificate. Unless the Army has it, you're not dead. So they can't pay your benefits. The certificate concerned shall furnish a certificate under subsection A upon receipt of an application for such certificate. Well, I'm asking the court to get it. Be more powerful them asking than me. A certificate appearing to be assigned by the Secretary concerned is prima facie evidence of its contents and of the signer's authority to issue it. The service member who has been reported missing is presumed to continue in service until accounted for. Well, I haven't been accounted for. I've never signed a DD-214. I never had a dental exam. Right? People have gone on leave. They never come off. They've never left the reserves. We went missing. I don't know how it happened. I just know, hey, I'm somehow I got a missing status in the government, and I'm still getting paid. A requirement under this chapter that begins or ends with the death of a service member does not begin or end until service member's death is reported to or determined by the Secretary concerned, or by a court of competent jurisdiction. They have to say you're dead, not just the certificate. Right? So I can see now where this is where you would take that certificate to the judge, like I am. It would be another piece of evidence if you're a survivor to say, look, right, the veteran died. I'm entitled to his survivor benefits. Would you please get them for me? Right? We're not making a court case out of it. We're taking our complaint to administrative office of the government to get it administered. So that's powerful stuff there. Yeah, where was I have that here? Member unavailable for signature. Okay, well, they could do that, but they have to send you one later to have it, to show that it's been fixed. And I never got one. And they have to send you an order. If you're going to be discharged from the custody and control of the military, they have to give you a discharge order. It says so in AR 635-200. So that's all the stuff I put in, right? And hey, they've made a court case out of both of them. I forget everything else. They actually made court cases, right? These are federal court cases. These two complaints. So if there's any attorneys out there that want to pick it up from here and take it to the goal line, I'm happy to let them do it because, you'll be paid by the government. I don't have to pay you, right? You can get paid under the Equal Access to Justice Act. We just got to get this stuff done. But what I need to get done is see these are civil and they need to be miscellaneous. There should be an M here, not a C. So that's why I wrote the letter. That's what I was told to do, write a letter, tell the judge. That's what I did. This is the last document that was filed on the 22nd, and there were like 5 other ones put in prior to that, having to do with them taking the complaint about there not being any Republican form of government and actually filing it and making a court case that has a date later than this date, so they didn't do it till afterwards, right? So I just have to assume they did it because I put the letter in. And then the chief judge, sua sponte, took jurisdiction of both the cases. Where was that at? Yeah, so this is the electronic, filing they give you. And it says here, notice of case reassignment, sua sponte, to Judge Colleen McMahon. Well, she would be the chief judge of the Southern District of New York Court. All right, so that was for the first one I did, and this is for the second one. Notice of case reassignment, sua sponte, to Judge Colleen McMahon. So how often do your cases get assigned to the chief judge? Right, because they did it twice. And so now I just need them to agree that, hey, these shouldn't have been civil cases in the first place. They should have been miscellaneous cases. But at least I got it to the right judge now to try to push that rope. Anyways, we'll see what happens. But it's what's going on, right? It's a great time to be alive. Get all sorts of things to try. And I'll let you know what happens next. Okay. Have a great weekend. See you now.